Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Michael Demaray. Michael is a highly respected estate litigation attorney in Silicon Valley here in California. I like to say Michael is the first one they look for and the last one they want to see. Anyway, he received his JD from Hastings College of Law, University of California in 1973. His honors include the Order of the Coif. He's a certified specialist in probate, estate planning, and trust law. Among his many distinctions, he is a past president of the Silicon Valley Bar Association and a fellow of the American College of Trust and Estate Counsel. Mike is also the author of the Litigation Tools chapter of the California Trust and Probate Litigation book published by California's Continuing Education for the Bar. As I said, Michael is a litigation attorney that specializes in estate cases. He spends most of his time in court or in negotiating and mediation and so forth in family disputes. Today, Michael and I are going to be talking about estate planning for second marriages. So I'm going to talk about hopefully how to avoid some of the problems that he has to deal with on a regular basis. Related to this, first of all, Michael is a California attorney. I am a California CPA. The laws vary somewhat from state to state, so you need to get your own legal counsel. This is just intended to be sort of an introduction to a continuing conversation. So with that, Michael, thank you for joining me today.
Thanks for having me, Michael.
Okay. All right. Do second marriage questions come up frequently in your estate litigation practice?
More frequently than otherwise.
Is it maybe your most frequent source of litigation?
Yes, without question.
Okay.
As you probably know, over half of marriages in California fail, and there are a vast number of second marriages. And often there are issues between the children by the prior marriage and the second spouse. Those issues may manifest themselves during the decedent's lifetime, but they almost certainly come up after he dies. And the issues have to do with a number of different factors, Michael. Basically, the fact that although in California your property is yours to do with as you please, sometimes your children, or our children, who have been raised in a fairly affluent manner, think that that's going to continue on after we die, that we still owe it to them after we die. And there's also issues about, gee, this is dad's money was inherited from our mom, and why should his second wife get it, and things like that. So I have a number of cases involving conflicts and contests between the surviving spouse and the children by the prior marriage.
Okay. Do all deaths of spouses in second marriages result in litigation?
No, not all. Often the marriage is a great success. The children are very happy that their father or their mother had happiness in the second part of their lives. It has to do more with the people, I think, than it has to do with any particular way of handling the second marriage. I mean, there was a movie called Howard's End, involving Anthony Hopkins, in which towards the end he was discussing how he was going to leave his property with his second wife and his children there. That's fairly uncommon.
Right.
Usually the problem is for the widowers as opposed to the widows. Older men, it seems, can't stand to be alone in the second half of their life, so they're immediately looking for the woman that they had been married to for 30 years, a second wife to take care of them, and of course they don't want to disappoint their children, since they're probably not going to have any more, and they wouldn't want to even if they did. So the second spouse, the husbands often tend to tell their second wife one thing, and the children by the prior marriage something else, to buy peace in the family or to buy peace for themselves. And then when they die, there's this distrust because the second wife was told one thing and the children by the prior marriage were told another. There are also other issues, Michael, involving what kind of trust or will was set up when mom was alive, and also whether or not dad continued to work during his second marriage. And there's issues of community property that may belong half and half anyway, and separate property, who's supposed to get that.
What are some of the common factors for most of the litigation that happens related to these second marriage situations?
Well, there are a number of different ones. One has to do with what kind of property the decedent had. If he had community property, half of that is his surviving spouse's. And then the issue becomes in, well, what is community property? He owned this business, for example, when he married the second wife. But of course, during the marriage, he worked in the business. Well, clearly the salary he took out of the business was community property. And if it's put in a bank account, even if it's put in his own name alone, after that's still his wife's, half's his. Often the case is that often when the man works in his own business, he doesn't take out a lot of salary, doesn't feel he needs it anymore, but he still likes working in the business. Well, that the courts have said is unfair to his wife. So what they do is they attribute a community property interest in the business to the value of the services he rendered. And so, believe it or not, after he dies, the second wife would be entitled to some interest in the business on the grounds that it was community property, which goes half and half. Of course, sometimes the deceased spouse tries to leave everything to his children. He may not be able to do that. There are issues involving a family allowance, probate homestead, which is the equivalent of either a post-death spousal support or the right to live in the house for a period of time. So there's just a whole number of reasons why. Some of the most common, believe it or not, even involve the husbands who had, or wives for that matter, who had gone to an attorney when they were still married. What was set up when they were married is something that's loosely called a marital deduction trust, ABC trusts, bypass trust planning, in which when the first spouse died, the surviving spouse was placed in charge of both the deceased spouse's property and the surviving spouse's property, and he can live off of that. But when he dies, his earlier dead spouse's money is supposed to go to her children. Well, sometimes, especially in the case of men, they don't keep things separate. And their attitude is, I made the money while I was married to your mother. It's mine to do with as I please, and I choose to leave it to my second wife.
Oops.
They can't do that. They can't leave the mother's share of the money to the second wife. Now, a number of times, the spouse from the prior marriage will have left it outright to her husband, which case it's his to do with as he pleases. But the children feel that that's unfair. Why should this woman who married our father less than 5 or 10 years before he died inherit not only his half of the property, but our mom's half as well? And a lot of times the children will go in to talk to a lawyer about trying to do something about that.
Okay. How can you avoid some of these problems? We've got another 1 week continuing education of the bar course, but anyway, just try to give us a few highlights of thoughts.
Well, I hate to say this, but you go to an estate planning lawyer, that helps with it. But sometimes people change their lawyers. And different lawyers have different opinions as to how to set up the estate plan.
Yes.
And even if you had good, competent legal advice, if you had children that you had raised in a luxury, often our children want their freedom at 18, but they fully expect us to continue to support them in the style to which we have made them accustomed. And the fact that we're now dead doesn't mean that that should stop. So they still look to their parents' estate as being the source of what they live on. And they're often shocked to find out that it's coming to an end and that now this other person, woman or man, is going to inherit everything. And they don't like that. So even if you had a very good estate plan, sometimes there could still be lawsuits just based upon the personalities of the people. And it's not always the children by the prior marriage that are the ones that are being difficult. Sometimes it's the surviving spouse. She might be made the trustee.
Yes.
And she's got certain powers, but she's got certain limits on what she can do.
Mhm.
And for example, if she has the right to invade the principal for her support, care, and maintenance, that's one thing. But she can't just take all the principal out and leave it to her second spouse or buy an airplane or something like that. There's limits on what she could do. The reason for that is that the husband might not have left it to her outright. He may have left it to her in trust with her as the trustee, and she, in effect, goes ahead and abuses her powers as the trustee by spending the money in a way that she's not supposed to spend. In those situations, the children and she wind up getting a lawyer and filing a lawsuit over each other.
Do you think it may be a good idea to have an independent trustee for one of these trusts?
Many lawyers will suggest that, but from experience, if you suggest to a husband and wife who have been married for 30 years that when the first spouse dies, the surviving spouse should give up control of the money to an independent person, you're almost certainly going to get an absolute no. Either from the,
It's a nice thought,
from
but
the husband and the wife, but they're not going to give up control, no.
Uh-huh. Wow. Okay. Okay. So a popular estate plan in the past, and I'm not sure if this is going to be happening so much in the future, but maybe it will, is what we call the QTIP, the Qualified Terminable Interest Property Trust. Do those work? How does it work when you go into real life?
Yes, if the
Yeah.
trustee does what he's supposed to do.
Okay.
For example, a QTIP trust was created at a time when the goal was always to defer, if not save, estate taxes. And as you may recall, it wasn't too long ago that anything above $600,000 was subject to an estate tax.
Right.
Now you've got to have an estate of more than $5,340,000,
Yeah.
and most of us don't have that big an estate.
Yeah.
So you often will have an estate plan set up from the past that has a QTIP, which basically says, and it often comes up in connection with a couple who come in and one of the spouses has children by the prior marriage.
Yes.
And he lives his half of the property, if he dies first, into one of these QTIP trusts that says, my wife gets the income automatically.
Mm-hmm.
My wife is also entitled to invade the principal for her reasonable support, care, and maintenance.
Mm-hmm.
But when she dies, whatever's left goes back to my children.
Mm-hmm.
Where this can be abused is, of course, who's going to be the trustee of that QTIP trust?
Yes.
Well, it's almost certainly going to be the woman that you're married to or the man that you're married to at that time. Now, the trustee is only supposed to use it for limited purposes, income only, and principles for support, care, and maintenance. But there's no limit on what their power is. They can go down to the bank doesn't know what the limits are, and pull all the money out, give it all to their kids.
Mm-hmm.
And it happens more often than you might guess, in which case after it's often not discovered until the surviving spouse dies. Then what you have is a lawsuit by the deceased husband's children versus the surviving spouse's children to try to get the money back, because it wasn't supposed to go to her kids, it's go back to his kids. And those are actually very frequent.
Mm-hmm.
It's not that people become more corrupt as they get older. They become more willing to do what they want to do,
Mm-hmm.
as opposed to what the prior agreement was. And after all, a lot of the times they were told to set these things up to save estate taxes, and it's not necessary to set them up it's not necessary to administer them anymore to save estate taxes. So they figure, well, in that case, it's mine to do with as I please, because had we known that the exemption amount was going to be increased from $600,000 to over $5 million, my wife would have left it to me outright, and I could have done anything I wanted to with it anyway.
You can rationalize away. I don't know if what's happening, of course, is that the nature of estate planning is changing, because in the past it's been largely tax driven. Now we're going to have, if you will, these social issues or whatever that are going to be other considerations, and one of them is going to be, and the reason why we'll still have maybe a bypass trust or a QTIP trust is that person is going to want to see to it that their share goes to their kids, And meanwhile, they want to provide for their surviving spouse.
Michael, that's probably the most important point that's made during this talk between the two of us. In the past, the lawyers were driven to save estate taxes. And it just so happened that this QTIP trust concept lent itself to protecting the inheritance of the children by the prior marriage. Just kind of worked out that way. Well, now you don't really need to set up a QTIP trust because of something called portability. For example, if you got two spouses, then without even having a QTIP trust, you can save estate taxes on one spouse is $5,340,000, and the surviving spouse is $5,340,000, even if this first spouse to die leaves it all outright to the second spouse. But sometimes the issue will come up, you can do it that way, Mr. Smith, but I want you to understand that Mrs. Smith, number two, could then leave it all to her children. And there's no guarantee that your children would get anything. And it can be kind of an awkward conversation because Mr. Smith turns to Mrs. Smith, number two, and says, well, gee, honey, you're going to take care of us all. And she said, sure, I will.
Oh, yeah.
So sometimes the lawyer will say, maybe you ought to have a QTIP trust anyway to be sure that your half, after she dies, goes back to your children. But as I said before, even in that situation, if Mrs. Smith, number two, decides to abuse her powers as trustee, there can still be a lawsuit over it.
Yeah. Well, and it can go both ways. So, because what happens is that when you put the wife or husband, the surviving spouse, in that position, and you've got a second marriage situation, and now they pass away, and let's say spouse number two is the trustee. Now you've got a situation that person is the obstacle between the children of the previous marriage and their inheritance.
You might call it that, yes. On some cases, you get a lot more attention by your stepchildren, asking you how you're feeling today, but they may not be that interested in you feeling good, as opposed to finding out if you're close to being terminal.
I don't know if I want to get a whole, but there are whole novels that are about this. It's, I guess, humanity and relationships. But there are other things that you can do. For example, you could actually provide some inheritance. If there's plenty, you could provide some inheritance for the children, maybe even after a first death.
Yeah, sometimes husbands and wives will leave property to their children when the first spouse dies. But it's actually pretty rare. Might leave them $10,000 or so, but not enough to make their lives comfortable.
Yeah.
And most spouses don't do that. Most parents don't do that. The kids don't get anything until the surviving spouse is dead.
Well, there's two reasons, I think. One is, you never know what's going to happen. And so they want to have all of the assets available for the care and maintenance of the surviving spouse. And the other is maybe an issue. There are trust issues, or they don't think the kids can handle it.
That's true too, and that comes up a lot too, because you'll see children they'll be shocked to find out that they don't get it outright when they're 18 or 21. The dad's in effect tied it up until they're 35, 45, 55, because they might have some chemical abuse problem or some employment problems that the dad wants to protect them from.
Okay, let's see here. Are children from the first marriage usually a good choice for a successor trustee?
One of the more tense moments of the estate planning conferences I do is when the surviving spouse dies or becomes disabled, who's going to take over? And there'll often be a protracted discussion about whether it's going to be your firstborn son or my firstborn daughter, that kind of thing. Sometimes they will make two people be the co-trustees, one of your children and one of mine. And that makes it a little bit more problematic to administer, because now you've got to get two signatures on every document.
Right.
But it does perhaps bring an element of security there, that knows that one child isn't going to be able to abuse their powers because it requires the consent of the other child.
Right.
That can be helpful.
It can. It also can mean that you end up going to court all the time because they can't agree.
It's amazing, Michael, when you say that, because you would think that people, given how expensive lawyers are, and they are, people would try to they would have a reason to work things out.
Uh-huh.
If we don't work things out, it's going to cost us more with lawyers' fees than it is if we try to gain any advantage from each other. But sometimes people just don't care. They want to have it their way, and they're going to spend attorney's fees, and they just don't care. So that's they should. It should be a reason for them to get together and work it out, but they often don't. And if that lawyer who's representing both of them can't get them to agree, he's got to say, you're going to have to each get separate counsel. Now we've gone from one lawyer to three.
Mm-hmm.
Think of how expensive that's going to be.
Yeah. Fun. Maybe you can talk for a few minutes about healthcare directives and durable powers of attorney for healthcare in this context.
Well, doctors and hospitals are very concerned about being sued for malpractice, so they don't want to be pulling any plugs unless they're pretty darn sure that that's what can be done. And we've gone through a succession of documents. We used to have something called a living will, and then a directive to physicians, and then a durable power of attorney for healthcare. Now we have something called the Advanced Healthcare Directive. And basically it gives you the right to appoint anyone you want to make the decision for you. And it gives them the right to make other decisions. Not only should the plug be pulled, but should you be given increasing amounts of painkiller, even though that may tend to cause you to check out a little bit sooner. If you're receiving nutrition and hydration by way of tube, the power to withhold that. Mm-hmm. But those work. You should have an advanced healthcare directive, because if you don't, and you've got children of the decedent by both marriages, or even more than one child, which many people do, the doctors and the hospitals are going to want everybody to agree about pulling the plug or doing any extraordinary surgery. And if you don't, they're going to tell you to go to court. In the meantime, you're hooked up to all these tubes, and you'd like something to be done with you, but you never had this advanced healthcare directive signed. So even if you have a wife, you can appoint your friend to make the decisions for you. But usually, if you know what's good for you, you'll appoint your wife.
Okay. Maybe you can talk for a few minutes about special considerations for retirement accounts that were earned before a marriage. Another 1 week seminar. Okay.
Yeah, it is. Federal law applies to what's called qualified plans. And under federal law, the plan has to go to the surviving spouse. Whether she has a community property interest or not is not the point. The point is that that's the way the federal law wants it to work. And sometimes, in order to leave the proceeds of your retirement plan to a child, you have to get that other spouse's consent. And some people think, well, I made this money, why should I have to get her consent? Well, because if you don't, then she can come back and say, sorry, under federal law, which preempts state law, it all goes to me. There are also issues, too, in terms of your ability to roll it over into your own pension plan, or if you have to take it out and do 5-year income averaging. Again, these are things you need to really talk to an accountant or an attorney about, because a lot of our money these days is saved in these income tax deferred plans. And who gets it is going to be a function not of just signing a beneficiary designation, saying, well, I earned this money before I married her, so I'm leaving it all to my children. You might be shocked to find out that she gets it all anyway.
Okay. Should an estate plan be made in a family meeting?
Lawyers often get into trouble with what are called conflicts of interest. You've watched The Godfather, and you had the consigliere, the family attorney. That's a book. That's a fiction. The lawyer represents a person or persons. He doesn't represent the whole family. He may try to keep the whole family happy, so he has a continuing source of business. But if he represents the husband and the wife, he doesn't represent the children. And if he does, there have to be certain conflict waivers. You got to know who your client is, and you're supposed to carry out the intent of your client, not the intent of the children. One of the big problems for lawyers is that after the client dies, the children get certain rights that they can enforce against the lawyer if he didn't do the will correctly. But by and large, you've got to identify who your client is. The estate planning lawyer is supposed to try to predict or prognosticate what's going to happen after mom and dad die. Mom and dad are often going to want the trustee to fix their children for them, which is always a joke. Or maybe if they give them enough money, they'll be able to take care of the things that they feel guilty about in terms of their upbringing. It doesn't work that way. And the lawyer who's drafting it should be aware of that and be able to counsel his client that there's only certain things the trustee can do. He can't fix your children to make them better than what they are, and you're kind of kidding yourself if you think so.
Okay. So we only have about a minute and a half left or so. Let's say a minute. So again, I'm going to throw it back to you, Mike, and maybe throw out some final word of wisdom related to estate planning in this second marriage context.
People talk about premarital agreements. Should you have one or shouldn't you? It's a matter of a judgment call. I basically think they're not that good an idea. The principal relationship in your life is supposed to be your marriage. You're obviously very attached to your children, but from the time that they're born, they're starting to move away from you. The person you share your life with is the important person in this way. And to start off a marriage by saying, this is mine and not, etc., is, I think, somewhat inconsistent with that. Plus, they've changed the law on premarital agreements now. It's much easier to set them aside. Much, much easier. And a lot of times they're not necessary. For example, if I have a bank account from before I got married, and it just earns interest after I get married, that's still my separate property. I could be married to my second wife for 30 or 40 years. It's still my separate property. Or if I inherited a bunch of money, that's my separate property. And why do I have to define what is mine and what is yours when that's already what the law is?
Okay.
Usually they come up in the context of a business, but even then I question whether or not that's appropriate.
Okay. Mike, thanks for joining me as my guest today. I really enjoyed this interview, and given our guests, our viewers, something to think about, and again, for a continuing conversation with your own counsel. We'll see you next time on Financial Insider Weekly.